last defense that we have is statutory authority. Now, what is a statutory authority? It is an authority established under a statute. Okay, an authority established under a statute or an act or a legislation. So what happens is, if an act or if something is done which is authorized, which is permitted under some act or statute, then it is not actionable, even though it would have constituted a tort otherwise. Okay, it is a complete defense, and the injured party has no remedy except for claiming compensation if anything has been provided under the statute. So what is a statutory authority? Some authority is established under an act or statute, and they are doing something which would otherwise have constituted tort. If it was not done by an statutory authority, it would have constituted tort. Simply because it's done by a statutory authority, it's not considered as a tort. Okay, and the victim can only claim for compensation if anything is fixed under the statute, otherwise not. Immunity under statutory authority is not given only for the harm which is obvious, but also for the harm which is incidental. Sometimes something may be very obvious, okay, and sometimes something may be related to it. So for both of the things, immunity has been provided. For example, we have National Highway Authority of India. That is established under National Highway Authority of India Act, as in it is a statutory body or a statutory authority which is being established, and it is responsible for construction of highways, widening of highways, etc. Right? So what National Highway Authority of India does is that they constructs a highway, and as a result of the construction work, a resident of the highway suffers from allergic reaction because of the dust. He resides nearby the highway and he was suffering from dust allergy. In this case, the resident cannot ask for injunction order to stop the construction work if NHAI is working without violation of any of the applicable guidelines. Just because they are a statutory authority, they cannot do whatever they feel like. They also are bound under some rules, regulations, guidelines. Okay, if NHAI was following all the guidelines, all the rules and regulations, they were not doing any violations, then in such cases, we cannot hold NHAI liable. Okay, even if this person is suffering from allergic reaction, he cannot ask the court to pass an injunction order that construction of this highway should be stopped because I am suffering. Okay, so this construction of road is of more importance as compared to this person's dust allergy. Same ways you might say that while highways are constructed or highways are widened, private property of many persons are also acquired by the government, right? So when property is being acquired, there also whatever compensation is fixed that we can claim for. Okay, a person cannot say that I recently painted my house with white color, this paint would get dirty or my house would get dirty, for that I should be getting compensation. As such, there is no provision that you have painted your house now, that too with white color, so you will be provided compensation. That is not there. So the person will not be able to. It just got disconnected. So a person cannot claim compensation like that, that the paint is faded or something like that. Those would not be available. Whatever compensation provisions are mentioned under the statute, that the person can claim. Environmental protection.
So, the example which you were quoting before this technical issue, that is also covered under this only, no? Where the properties of public are acquired just to widen the height.
Yes, so property of public is being acquired. There also whatever compensation is fixed, that only they can claim for it.
Okay.
Okay, then the Environment Protection Act 1986, it empowers a person to enter any premises and inspect whether rules framed under this act are complied with or not. So there will be different like manufacturing units or different like bodies are there, right, who are maybe in an industry, in a factory, etc. Certain work is being done. Okay, now what happens is, it might happen that they are dealing with some hazardous materials. Okay, they are dealing with such kind of materials wherein it is causing loss to the environment, harm to the environment. Now, it's not possible that straight away we will say that all the factories should be stopped because it is causing harm, because it is destroying the environment. That is not possible, right? We need industries, we need factories. So what happens is, there are these environmental laws under which some guidelines are being issued, that you need to follow these guidelines in order to uh, bring down the rate of emission or bring down the rate of loss that you are causing to the environment. All right, and in order to ensure that factories and industries are actually fulfilling or following these things, some inspectors are also being appointed. Some people are being appointed who can go to those premises, and like a surprise visit they can give, and they can inspect whether these rules and regulations are followed or not. If not, penalty may be imposed. Okay, so it is very much important that these inspectors who are appointed and authorized under this legislation, Environment Protection Act, they are given this authority or power that without previously informing, they can enter such premises, they can enter those factories or manufacturing units to do the inspection. Because if they tell that, okay, 2 days after I will be coming, they will obviously try
They'll
to
make arrangements.
make arrangements, and their visit will make no sense. So what happens is, these inspectors are authorized under this legislation that you can give surprise visits. Okay, so what they will do is that they will enter such premises during office hours and do the inspection. But if same thing a normal person like you or me would have done, that we simply entered their premises, we simply entered their manufacturing unit, it would be considered as trespass, right? Because it's not permitted, an outsider would simply go there
Yes.
without permission. Just because this person is authorized under the legislation, it is called as statutory authority. And even though otherwise it would have been a tort of trespass, because he is a statutory authority, his action will not be, the person cannot basically file a case. Okay, same applies in case of Factories Act also. Okay, there is a legislation called Factories Act. Under that also some inspectors are appointed. Okay, because Factories Act says that you need to take some safety measures, only skilled employees should be hired, they should be given proper safety equipments, this, that, multiple guidelines are there. Whether those are followed or not by the factories, for that again inspectors are appointed. They also can give surprise visit in the factories to see it. There also it will not be considered as trespass or anything like that.
I just have a doubt. Generally, like in movies or in serials, we see that whenever a policeman comes to somebody's house for searching something, and if they have got hint of something is going wrong in that place, they'll just come and do inspection. During that, we will see that whether you have search warrant or not, they'll ask the other party, common people. Is that a necessity or it will cover under this guideline?
No, that search warrant would be necessary. Based on that only they can do the search. Okay, so court would ask police officers that maybe we are suspecting that something might be there in this person's house or in this certain company or in this certain premises. So you go there and you do the search. So search warrant would be very much necessary.
Will there be any other separate legislation which is governing them, or it's their procedure itself? Because in this case, here, people from government side, they are not required to carry any such warrant or the notice which is required to be shown to company people. They can just
For
walk
this
in
one, you
and
are
carry
asking?
on the inspection. Yes, this
Yeah, for
point
this
of
one,
view.
the legislation itself, like this person is hired for that purpose only, that you do surprise visits and you do the inspection. So that authority is given under this legislation. But if you talk about police officers, yeah, we do have a legislation, CRPC, Code of Criminal Procedure, which talks about powers and functions of police officers. There also police officers are given their own set of powers, their own set of functions. There, yeah, police officers are having the duty of investigation. For that, they can do it. Courts can also ask, those provisions are also clearly mentioned under CRPC. Court can ask police officers that you go do this inspection. Courts may ask some government bodies that you like sell certain property or certain goods of this person, whatever money you are getting with that, you do this thing like that. Court is having power. So everything is mentioned under CRPC.
Okay.
Okay, so we have this case. Okay, so Hammersmith Rail Company versus Brand. In this case, what happened is the value of the property of plaintiff depreciated due to the loud noise and vibrations which were produced from running trains on the railway line, which was constructed under a statutory provision. Now, when railway lines are constructed or other things are done, they are also done under statutory provisions only, right? Some authorities would do the uh, like analysis, and after that approvals would be taken. All the procedures are followed once approval is taken. So what happened is there was a person living over here, and there was no railway track or anything like that previously. But after that, what happened, the railway track was constructed, and because of this noise and vibration, the value of his property, it depreciated, that it is not a very peaceful place to live in. So he filed a case. Okay, the court held that nothing can be claimed for the damage suffered as it was done as part of statutory provision. And if something is authorized by any statute or legislation, then it serves as a complete defense. The defendant was held not liable in this case. So we cannot simply say, because otherwise everybody would say like that only, right? Nobody would prefer a railway track or airports near their house, just next to their house, because it would be disturbing. So if everyone starts complaining like that, where we will set up these railway tracks or airports and other stuff like that? Because it is very much important, right? Rather than considering that this person's value of the property depreciated, what is more important is connecting different states through railway and other things like that, right? So there it was not being accepted that yes, otherwise if your neighbor would have set up a meal or something like that, might be it would have been considered as a tort, you would have got the remedy. But here, because it is a statutory authority and railway departments need to do these kind of things, so it was not considered. He was not given any sort of compensation. Okay, so similar to remedies available to aggrieved parties, importance of defenses to alleged parties for an important is an important part of law. So when we talk about aggrieved party who has suffered loss, the victims, for them multiple remedies are available under law. How much important these remedies are, same importance is of defenses, because it helps the defendant to escape the liability if a false case is registered, or if he was not actually liable, he can escape the liability by proving any of these defenses. Many a times the defendant is innocent and the victim of circumstances such that the liability arises from their action after all essentials are met in law of tort. The general defenses which we have and in law of torts forms an important part of the law, which help the defendant to get absolved from any sort of liability that may arise. For their proper application in individual cases, a proper understanding of these defenses are important, because some of these look like overlapping, some of these look like similar to the other type of defense. So we need to know in what situation which defense would be applicable. And if the defendant is able to prove any of these defenses, he can most likely escape the liability as well. Okay, so these were the 8 defenses that we have under law of torts. Any of these defenses may be proved and claimed by the defendant by giving proper justification or proper evidences. Okay, this is clear, right? Defenses.
Yes. Yes.